Happy Wednesday, awesome law nerds. We are gathered here today in this hallowed court of law nerdness to talk about James Charles getting sister sued. And yes, I made the joke on Twitter, and then I saw that, the viewer's voice had also named a video that, and I was like, we're on the same wavelength because it just makes it so easy. I have missed you guys. I've been a little under the weather, but we're going to just call this to order. I'm going to go over this lawsuit. This lawsuit's been going on for a hot minute. So we're going to go over everything that's happened, and then we're going to do a deep dive into what's alleged in the complaint and the answer. So an overview, like a broad overview, what's in the complaint and what's in the answer, because at the end of the day, that's what everybody wants to know. And that's where the interesting stuff is, right? In the complaint, what they're alleging, and in the answer, what they're saying. Not in all the legal wrangling that's happened in the, year or so this has been going on. So let's just dive in. We have to give a huge shout out to Def Noodles, who reported this on Twitter. I don't know who sent it to him or how it was found, but that is where I saw it. And that's where y'all tagged me in it. If you don't follow me on social, at the Emily D. Baker is where it's at. And we are going to just get into all of it. I should have grabbed the gavel. I didn't, but now I have it. This one's our facts, not fuckery gavel. We're called to order. Here forth comes the case of the sister suit. Let's get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. All right, when I say a year, it's because this complaint against James Charles by a former employee was filed on March 2nd, 2020. Yes, we didn't know. I didn't know. You didn't know. We didn't know. But it's been going on since then. So quite a lot has happened. The complaint was filed. And again, a complaint is the document saying, hey, you get out of my heart. Get into my... No. Hey, you. I don't like your girlfriend. Hey. No, not that either. Hey, you did some shit. And I think that shit is shit you shouldn't have done. So I'm going to go ahead and sue you over it because I think that I have grounds to sue you over the things that I say in this complaint. Complaints are allegations in the form of a legal document. They have not been proven to a court of law. They're people saying shit in allegations to make sure that everyone knows what they are doing. So that is the stuff we're going to dive into after we do the overview, which we're doing right now. So, hey, you did some stuff. I think the stuff you did is illegal. We're going to do that. After the complaint is filed by the plaintiff, the defense can file a number of different things. They can file procedural motions. They can file an answer. There's lots of stuff. We've seen different options in other lawsuits. We saw in the Jeffree Star suit with the Anna Nicole Smith estate that they let the court know, hey, we're going to go ahead and mediate. We'll be back if we need you. We saw in the Tati Westbrook without a crystal ball case that the defendant in that case, KJ, filed a motion to dismiss based on jurisdiction. We saw Tati Westbrook as a defendant in her own business partner suit with Clark Swanson file her own motion to dismiss based on venue and jurisdiction. In this case, the defense filed a motion to compel arbitration and stay the proceeding on April 10th, 2020. What that means real fast, arbitration is a formal and binding type of mediation where the parties get together with a person and they try to sort shit out amongst themselves. It is not uncommon for employment contracts to have a mediation or arbitration clause. That is what the defense alleges in this case. Hey, you signed an employment agreement, and in that agreement, it said we have to arbitrate. So really, you shouldn't be suing us. We should be in arbitration. So that was filed on April 10th, 2020. There were oppositional motions filed with regard to that, but On June 24th, 2020, the court granted the order for arbitration and stayed the proceedings. A stay is just a stop, drop, open up, put them at, open up, shop. I messed that up epically. We're going to do a different stop next time because there's going to be a lot of stops in this whole, road so far music in my head this evening. There may or may not be cold medicine involved. It just is what it is. So, stay the proceedings, meaning the normal course of a civil case has timelines that need to be met. The stay for arbitration means literally put a cork in it. We've got to go to arbitration and we'll be back. So the proceedings were stayed in June. Well, it didn't last that long. September 21st of 2020, plaintiff filed a motion to lift the arbitration stay. Your Honor, relieve us from the stay. Let us proceed with the lawsuit. Why? Well, the arbitration was closed because the defendants didn't pay their arbitration fees, defendants being James Charles and Sister LLC. So the plaintiff's former employee that is suing James Charles came in and was like, hey, Your Honor, they didn't do their homework. We'd like to be relieved from the stay and we'd like this court to proceed along. We would like to move forward in litigation here in court since they didn't do what they were supposed to do. Defense filed an opposition to that saying, yeah, about that. They didn't tell us things we think they should have told us. Plus the emails were going to an attorney that was on maternity leave. Plus it's not our fault. It's their fault. There was litigation over it. The court came back and went, no, that's fine. We're lifting the arbitration stay. I am not convinced by all of defense's arguments here. Plaintiffs also asked for sanctions in that. The court was like, no, what we're not going to do is issue sanctions over this, but we're also not going to maintain the stay for arbitration. You had your shot at the apple. No arbitration for you. Move along to litigation, my friends. Defense, James Charles and Sister filed more motions going, but Your Honor, wait. Really, seriously, we should go to arbitration in this case. And the court was like, you've brought me nothing new, and I'm not going to go ahead and do that. Literally, the court order in that second wave of litigation said, I find that there's no new facts or evidence. So yes, you've brought me nothing new. We're not going to do that. Go ahead and answer the lawsuit. The defense, both James Charles as an individual and Sister LLC, answered this lawsuit in December of 2020, started the litigation process, and then filed an appeal. So now everything is stayed pending appeal. So this has gone up to the appellate court to see if, the court's like, stop right there. You don't get to arbitrate is actually going to stand, and we'll see what the appellate court does. So the next court date in this case, in the trial level court, is set for, December 22nd, 2021. Why? Because it has gone away to the appellate court. Go. Let the appellate judges adjudicate, and we will see what happens. So for our purposes today, we are going to go through the complaint, the shit that they said that you've done, and the answers. The shit I said I have not done. Because that's the most helpful. And then I will answer questions. Now, chat. I will be answering questions during Q&A so that we can just go through this without it taking 10 million years. And then I will get to super chats, and then I will get to the YouTube things, and then I will get to questions. So know that that's coming, and I will go back and try to find the super chats. Absolutely. And there's other information in here. So if you want to know what the employment contract looks like, it's in here. We'll do that in a separate video. If you want to know about the back and forth over arbitration and all the litigation that happened in there, please let me know, and we will do that in a separate video. Today, complaint, answer, questions, because that, A, is the most interesting, and B, unless you want to go over the employment contract, and we will do that maybe at Friday Night Live. So let me know. We will absolutely do it. Okay. It is good to see everybody. Thank you, chat, for coming in and riding on a random day. And I've got my fun mug. If you guys are on Instagram, you will see that this got sent to me. It's actually got like glitter and stuff in it and a sparkly top. I'm very hydrated today. We're sister sipping. Gosh, it's going to be all sister jokes. It's going to be all the sister jokes. All of it. All of it. Look, be patient with the sister jokes because it's funny to me. And again, this is employment litigation. This can happen to any influencer. I think, Emily, thoughts before we jump into this complaint, that we will see more of this happening. And we will see more of these employment litigation suits happening. I will talk about this if you're curious about what I think will happen with like David Dobrik and Jeff Wittick. We will talk all about the different things. It is so good to see you guys in the channel. If you want to share this out on Twitter to your favorite channels that are talking about this so they have the lawsuit, go ahead and share it with them. I saw Adam McIntyre in the chat. Hello, Adam. I know that Aphrodite made a prediction on this and other channels are starting to talk about this lawsuit. So let's get to the allegations. I hesitate to say facts because again, they are not facts. They are allegations. So we're going to get to what is alleged to have happened in this case. Let's make sure that my screen sharing on. Look, you guys, it's been a minute. She's sister sick. Oh my God. You guys, when I said there was going to be a lot of it, there's just going to be a lot of it. Let's get into this complaint. Okay. Former employee Kelly Rocklin, Kelly. We're just Kelly, no disrespect. We're just going with Kelly because A, it's easy for me, and B, it's easy for me, versus Sister LLC and James Charles Dickinson. Normally, if he was going by a stage name and his last name was not well known, I would have taken that out. However, in his most recent apology video, he did say, sometimes I just want to be James Charles Dickinson. I'm like, well, that video has quite a lot of views. So it's out there now. So we're just gonna go with it. There are 10 different causes of actions in the specter of employment law. Failure to pay wages upon separation. Sure can't do that. Failure to provide minimum wage compensation. Failure to provide overtime and double time. Waiting time penalties. Disability discrimination. Failure to provide reasonable accommodation. Failure to engage in good faith interactive process. Retaliation. Other code of retaliation. And wrongful termination in the unlimited jurisdiction because the amount in controversy is over $25,000 and there is a helpful demand for a jury trial. So let's jump into what is being alleged by Kelly as it refers to James Charles. Comes now plaintiff Kelly, who for causes of action against defendant James Charles, an individual, and Sister LLC, and Does 1 through 50, complains and alleges as follows. Plaintiff Kelly is an individual who was employed by defendants James Charles Dickinson and Sister LLC in Los Angeles. I will say, when the employment contract was attached to another declaration submitted by defendants, I was happy to see that there was an employment contract, that there was an employment relationship here, and this was not just somebody working as a contractor. Like on that, I was like, good, here we go. There's an attorney involved. Kelly, in a separate declaration later, states that she did not have an attorney review her employment contract, but there was an employment contract on James's behalf written by an attorney with regard to this. And I was encouraged to see that because if you're employing people, you need a contract. Lawyer notes aside. Plaintiffs are informed and believe, and based thereon allege, that defendant James Charles is an individual residing in California. Plaintiffs informed and believe that defendant Sister is a LLC organized in Delaware and is doing business and is qualified to do business in California with its principal place of business in Los Angeles. Plaintiff is alleging the Does. The Does are, hey, there might be other people that are involved in this or work for the company or have a hand in this in some way. We don't know who they are right now. Through discovery, we might discover who they are. So we're alleging them because otherwise we lose the ability to add somebody to this lawsuit because the defendant wasn't on notice. So there we go. Plaintiff is informed and believed and alleges that at all relevant times, whether named fictitiously or named as Doe. They were the merged entity subsidiary. So this goes into all the different corporate potentialities, agents, what have you, that they are defendants. They are named defendants as Does. Venue and jurisdiction. Notice this is one little sentence. You know why this is one little sentence? Y'all are experts in jurisdiction at this point. If you watch this channel for any length of time, you're like, oh, what kind of jurisdiction do we have? Look, the company operates in LA. James Charles lives in LA. Plaintiff lives in LA. Guess where this lawsuit is brought? That's right. State Court, County of Los Angeles. You know, the same courthouse where you're going to get your Britney Spears hearings and stuff like that. We'll talk about that later. All right, let's get into the important part of any lawsuit for our purposes, the first line of the statement of facts. This case presents the compelling story of a hard-working employee who was terminated by Sister in retaliation for her medical condition and her engagement in protected activity in relation to her former employer, Costel Enterprises, Inc. Costel, Erica Costel, Jake Paul, Team 10. Y'all can talk about it in the chat. But that's who it is, like Erica Costel. That's who that is. So that's our first line. This is a lawsuit based on the compelling story of a hardworking employee who was terminated by Sister. Look, I like this lawsuit. There is sass, but it is not overly sassy. It is clear and concise, and it's easy to follow the story of what happened. So let's follow the story of what happened way back in 2018. Doesn't that feel like 100 years ago? April 2nd, 2018, Kelly began her employment with Sister as a video editor. Through the initial period of her employment, Rockland was consistently praised for hard work, dedication, and talent by James Charles, owner and operator of company. July 9th, 2018, in recognition of her stellar performance, Kelly was promoted to producer of Sister. Rockland gladly accepted the position. However, after promoting her, Sister never hired a replacement editor, which required her to perform both roles simultaneously. Sounds like a lot. This required Rockland to work upwards of 12 hours per day, 7 days a week, to meet the ongoing production needs of Sister. That's a lot of work. And if you're an employee and you're not an exempt employee, overtime is what's required in the state of California. Despite performing both roles and working extensive overtime hours as a result, Rockland was not provided overtime compensation. That, if true, is going to be a big problem, because that's one of those things on the law. It's like you either did or you didn't. You either paid overtime or you didn't pay overtime. And an editor is going to be a non-exempt employee, in my opinion. Kelly informed defendants these grueling hours were unsustainable and requested the editor position be filled. She also informed defendants that she was not being paid overtime wages. Right. Hey, I'm working all the time. I think I should be paid. Throughout her employment with Sister, she never received any wages for the overtime hours she worked. In response, Charles promised he would repay by providing her a raise in 6 months' time. Hey, sister, I know that you're working all the time, but let me get you in 6 months and I'll pay you the back overtime. Look, that if true, maybe not the way you'd want to go ahead and handle that in a workplace. Could you imagine your boss being like, oh, yeah, that's right. You're entitled to overtime. I'm going to give you a raise in 6 months. We'll take care of it then. Can you imagine? The problems that creative space. Providing her a raise in 6 months' time that would compensate her for the unpaid overtime premiums. Let me get you later. Her incredibly long working hours began to take a toll on her physical and emotional well-being. She continued to raise these concerns to defendants and implored them to hire a new editor so she could return to her normal working hours. Nevertheless, a new editor was never hired during her tenure with Sister. On September 4th, 2018, she suffered a head injury while in the presence of Mr. Dickinson that resulted in her experiencing headaches, temporary loss of consciousness, confusion, amnesia, dizziness, ringing in the ears, nausea, vomiting, slurred speech, delayed response, fatigue, difficulty concentrating, sensitive to light and noise, sleep disturbances, psychological adjustment problems, anxiety, and depression. Sure sounds like they just described concussive symptoms and brain injury type symptoms, which from hitting your head. You know, would be what that is, says Emily, who once a long time ago worked as an EMT, but this is not medical advice. I'm not a doctor, nor do I play one on television. I'm married to one. That doesn't count. The injury resulted in Miss Rockland losing consciousness and being admitted to the emergency room via ambulance. So not only is there a head injury, but there's a head injury resulting in the loss of consciousness, making me wonder what happened. But we're not going to get the answers of what happened back in September, other than she suffered a head injury while in the presence of James Charles. So he knew he was there when this happened. There's nothing in this complaint that indicates it was a result or it was caused by work, just that it happened while he was there, so he was aware. But she lost consciousness and was taken to the ER via ambulance. That's more than just a slight thing, my opinion. Her hospitalization caused her to miss time at work and caused delays in meeting video production goals. Well, one would assume that that's the case, wouldn't they? I'm sorry, you're in the hospital with a head injury. Can you go ahead and let me bring you your laptop and see if that doesn't cause headaches or issues with focus. Anyone who has had a concussion, I'm sure can empathize here. I've had migraines with some of these symptoms. There's no work happening. This goes on to say, rather than showing any concern or empathy for Kelly's serious medical condition, James Charles callously accused her of not being dedicated to her job as a result of her work being delayed while she was hospitalized. Upon returning to work, Charles convened a meeting with her wherein he chastised her for falling behind on video production during the period she was tending to her medical condition. I'm so curious who's doing HR for Sister LLC, because I feel like an HR person would have maybe stepped in here and been like, what we're not going to do is chastise someone for being hospitalized with a head injury. Just my wild and crazy speculation here. But who am I kidding? Influencers don't have HR. We've learned this, haven't we? Specifically, Charles informed Kelly that he was disappointed with the fact that production projects were not completed while she was hospitalized. Mr. Dickinson, I'm just going to say James Charles, it feels weird to say Mr. Dickinson, went as far as to say, quote, I want to be your friend, but I'm your employer. And the fact that your health was the reason why the video didn't go up doesn't make it a reason for an upload not to take place. YouTube at all costs. Look, YouTube at all costs. YouTube at all costs. I'm going to need a timeline of like what was happening in September 2018. What Geddon were we in? Were we pre? Were we post? I need a chart. I need a chart. I need a chart with where we were on the spectrum of sister scandals. And I'm gonna need a whole ass graph of where we were sister scandal wise in September 2018. So I would imagine, if this is in quotes, Emily's speculation based on lawyer experience, if this is in quotes, I would expect that is somewhere where they can back that up, text, email, something, because that's not a he said, that is a double quotations. I would imagine that is written somewhere and that she has that. My speculation. Concurrent with Mr. Dickinson's in-person disregard for Rockland's medical condition, he would send her text messages stating her health condition was important to him. Look, sister, your health is so important, but also we have an upload schedule to keep. So could we just? Kelly texted Charles regarding his duplicity, questioning why he appeared considerate of her medical condition in text while repeatedly chastising her for missing the time during in-person conversations. Dickinson responded by denying that the in-person conversation occurred, stating, "Messages like this make me question whether or not you're actually 120% invested in the team." Yeah. I mean, look, girl, I know you were in the hospital, but like, schedule. On September 11th, 2018, Kelly was readmitted to the hospital for a fourth time. A fourth time. Again, not hard to prove in discovery if you've been to the hospital 4 times in September 2018. So this is September 11th, 2018. The injury is from September 4th, 2018. So between September 4th and September 11th, Kelly went to the hospital 4 times. Shit was still not okay, is what that says to me. Rockland was readmitted. Also, that's not just like, hey, I need to go to the ER. Hey, I'm going to urgent care. They said readmitted. Readmitted to the hospital for a 4th time in connection with her head injury. Her treating physician diagnosed her with a concussion and instructed her to take a week off of work in order to recover. Yeah, concussions are nasty AF and can have really, really long-standing side effects. If any of you guys followed the amazing Melissa Urban on Instagram, she's the founder of the Whole30. It's okay if you're not a Whole30er. There's no judgment. I mean, I eat sugar and Oreos, but neither are Whole30 approved. But she documented her concussion journey, and it has been a very, very long journey of reoccurring symptoms and what she's dealt with her concussions. So it is, concussions are actually really fucking serious. Kelly informed Charles of her medical condition and her need for a leave of absence. Charles responded by stating he knew her close friend was in town and that she should enjoy her week off with her. Oh yeah, enjoy your week off, sister, implying that she was not being truthful concerning her head injury and need for accommodations in connection therewith. On September 19th, upon her return from medical leave, Sister callously informed her that she was being terminated due to poor performance. You haven't been getting videos out in the time that you've been busy going to the hospital, so we're gonna just go ahead and let you go. Again, any of the law nerds that work in HR, I feel you screaming on the other side of your computers. I hear you. I feel you. It happened in my head too. Notably, prior to her medical condition, Sister never took issue with her performance and had instead just promoted her to producer. In fact, 2 days prior to her concussion, JC had showed Kelly praise due to her excellent performance. Thus, any perceived performance issues were a direct result to the concussion, repeated hospitalization, and inability to work the grueling schedule defendants demanded of her during the time period. Yikes. May 21st, 2018, Kelly made a request for employment files from her prior employer, Costell Enterprises. So this is well prior to that September injury. On June 20th, 2018, Nixon Peabody Peabody, it's just going to be LLP. This is a legal law firm. Yes, I'm like, it's a legal law firm as opposed to the other types of law firms, the non-legal ones. Goof. It's live. Responded to the records request. Coincidentally, Nixon Peabody LLP, specifically a partner at the firm, Ellie, I'm not even going to try, Altschler, damn it, I tried, happens to also represent Sister. So what we've learned is that Costell Enterprises, or Erica Costell's business arm of her company, is represented by the exact same attorney that represents James Charles. They're trying to imply here that, well, we'll read what they're trying to imply because they're going to just say it. There's more implication under it, but we'll just go on. Kelly is informed and believes that based thereon alleges that her termination was substantially motivated by Sister becoming aware that she had engaged in protected activity, namely requesting her employment records from Costell Enterprises and her contemplated legal action against the company. So what they're saying is that, look, you're allowed to sue a prior employer. Your current employer can't take retaliatory action against you based on something that you're engaged in, and generally wouldn't know that. And they're saying the reason that they might have known that is because it's the same lawyer. I mean, just as easy that Erica could have told James, but there's a solid connection they are alleging here with the attorney. Whether an attorney would disclose one client's business to another client regarding the same employee without permission, well, that assumes there's no permission, is a whole different thing together. That's not to say there wouldn't be permission. We could get very into the weeds on that whole conversation. We're not going to. James Charles may or may not have known that she was going after Erica Castell's company, or getting ready to, by requesting her employment files, which, by the way, you are entitled to. And I know that Kelly has been posting on social media that she had pursued and potentially won in litigation against Erica Castell. If you're interested in that litigation, let me know in the chat or in the comments if you want me to tell you what happened in that litigation. We'll just pull that up and do that one next. I mean, influencers just out here being sued. This action is brought by plaintiff against defendants, alleging inter alia, disability and or medical condition discrimination, failure to provide reasonable accommodations, failure to engage in good faith interactive process, and retaliation under FEHA, the California Fair Employment and Housing Act, violations of Labor Code Section 98.6, and wrongful termination in violation of public policy. At all applicable times mentioned in this complaint, defendant regularly employed 5 or more persons, bringing defendants within the provisions of FEHA. Plaintiff has adequately exhausted all of her administration remedies under FEHA and obtained a, quote, right to sue letter from the Department of Fair Employment and Housing against defendants. There are procedural hurdles that you need to go to before you can sue an employer. There are remedies you can take, and she has, according to this, gone ahead and done that. So what we're going to see in these causes of actions are what's being alleged and against whom. So this one is against all defendants, meaning James as an individual, and then the company as, well, a company. Plaintiff alleges and incorporates by reference all the shit above. That means, hey, everything we said in the statement of fact applies, plus this other stuff that applies to this claim specifically. And when it gets to this claim specifically, it's just going through the allegations. Remember, you can move to dismiss a complaint if things aren't alleged properly, saying you have failed to state a claim upon which relief can be granted. So they have to say, under this law, these facts mean this happened, and it has to be pled for every single allegation. And that's what we're going to see here in these pleadings. This is, you are required to compensate employees for all hours worked. This is the law that says that. You're required to pay employees wages upon separation of employment. This is where it says that. By the way, in California, you don't have a lot of time to do that. When someone leaves, you have to pay them. We talked about this in the Kanye West lawsuit with regard to Sunday service. I will link that somewhere in the description after the live. We talked about that. When people are terminated, you have to give them their money. You have to pay them. And often you have to pay them that day, that moment. Defendants have failed to pay plaintiff proper minimum wage compensation or overtime compensation for any overtime hour worked under the aforementioned wage order and regulations. Plaintiff is entitled to recover compensation for all hours worked, but not paid by defendants for 3 years prior to filing this action. So they're going to go after overtime for 3 years, plus non-payment of wages, damages, penalties, attorney's fees, interests, and costs. When I say that the California Labor Code does not fuck around, it's because it does not fuck around. In my opinion and experience, but in no way as legal advice, if these are very easy for plaintiffs to prove, either you were paid or you were not paid. There is documentation that shows if you were paid or if you were not paid. These become very factual allegations because it doesn't matter. It's like, la, 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 la. Nothing else matters. Were you paid? Yes. No. Were you paid on that date? Yes. No. This, I think, is why Sister LLC is fighting so hard to go to arbitration to try to cut out some of these fees, but also some of the penalties, because this is something that is, if these allegations are as they are and payment did not happen, this is very, very hard to win on account like that. Not impossible, but if the facts are there, there's nothing else to do. You have to pay it. If you did not, then you are done. So we will see. We will see. And I looked at the employment contract, and the employment contract was for a starting base rate of $5,000 a month as a full-time employee, but that's like $1,000 a week. But I don't know if that, when you break down to 8 hours a day, if that's going to meet the minimum wage plus then the overtime here. Second cause of action, failure to provide minimum wage compensation. Whoop, there it is. Defendant failed to pay the minimum wage to plaintiff for all the overtime hours worked and the entire course of her employment. So again, you have to pay a minimum rate of overtime. If she was receiving the $5,000 a month, again, there could have been additional compensation that is not indicated in that contract. But assuming that number, if more was not paid at 12 hours a day, you're going to get a number that is less than that minimum wage number. And there has to be overtime when you work overtime. I'm sure that there are records, though that might be difficult if people weren't clocking in and clocking out. So proving up the amount of time might be a little bit more difficult depending on the record keeping here. Third cause of action, failure to provide overtime and double time compensation. By defendant's policy of requiring non-exempt employees, this is an employment law designation. There are some employees that are exempt from some of these rules where you can have them on salary and they can work crazy hours and they aren't compensated for overtime in the way hourly employees are. They are alleging that she is non-exempt. I think it would be very hard for them to prove, but that is getting very technical into employment law, well beyond our purposes here. So requiring non-exempt employees to work in excess of 8 hours a workday, 40 hours in a work week, without compensating such employee at a rate of time and a half for overtime hours worked. They are saying, yeah, that should have happened because that's the law, and it didn't. Again, this should be fairly easy to prove by documentation. They're also saying that there was an excess of 12 hours in a workday or of 8 hours on any seventh day of the work week without compensating an employee double time. So if you're working every day of the week, that is double time. If you're working more than 12 hours a day, that 12 plus is double time pay. And that wasn't done. Waiting time penalties against all defendants. You have to pay it when they separate from employment. Defendant hasn't done that yet. So there are statutory penalties that you're entitled to for not paying that when you were supposed to. And that is an additional 30 days of wages. So you didn't do it. There's a fine. Fifth cause of action, disability discrimination against sister only. So this is against the company, saying that essentially because of the head injury became a disability. And there was unfavorable treatment because of the head injury, which was a disability. At all times mentioned, plaintiff was a member of a protected class in that she suffered from an actual or perceived disability, specifically an injury to her head, which resulted in a concussion. She was treated less favorably than similarly situated coworkers with respect to the terms, conditions, and privileges of her employment. Defendant's policies and procedures were applied differently to her than other employees based on her disability, and on and on with the technical language of that she was harmed and suffered actual damages and financial loss because of the injury. This is all going to the fact that she was fired, they're alleging, because she suffered this injury, and then her performance suffered. Failure to provide reasonable accommodations against sister only. Under the law, if somebody has a disability that is protected, you have to reasonably accommodate them if you are an employer. Plaintiff alleges that she could have fully performed her duties and functions of her job in an adequate, satisfactory, or outstanding manner if she was provided with reasonable accommodations as requested. The nature of those requests isn't greatly spelled out here, but you are allowed to ask for accommodations from your employer. Now, there are boundaries to that, but given that this happened all within a month, one has to ask themselves how much the company tried to accommodate her to do her work after this injury. So, and then again, as a direct result, there was damage to her in the financial realm because she lost her job. Failure to engage in a good faith interactive process. Interactive process is what an employer has to do to help you work after an injury. I've been through this with employers myself after a spinal fusion. The thing about large employers is they have a process to handle all of this and they know what they're supposed to do. And if they don't, then there's normally someone you call and go, "Hey, they're supposed to do this." And they're like, yeah, we'll handle it. While plaintiff was employed with defendants were aware that plaintiff was disabled and required accommodations. Plaintiff made reasonable accommodations or requested reasonable accommodations and was terminated upon her return to work. Again, it doesn't spell out what those accommodations were, but that is something that will go on during discovery and is probably known to both parties because they engaged in these conversations together. But she got back to work and was terminated for her performance during seemingly the month where she was struggling with this concussion, is what it seems from this complaint. Again, complaints written in the light most favorable to the person writing them. 8th cause of action, retaliation against sister only. Plaintiff engaged in protected conduct protected under FEHA. Plaintiff informed defendants that she was disabled and needed accommodations in connection therewith. Thereafter, rather than providing her with accommodations, they retaliated against her. The acts of retaliation include, but are not limited to, terminating her employment upon her return to work from her leave of absence. And then they go through the law that, says basically, you can't go ahead and do that. Retaliation under the labor code against all defendants. Again, a different type of retaliation. This is as alleged to the perceived connection between her wanting to initiate, Kelly wanting to initiate legal action against Costell Enterprises, and sister having that knowledge, or at least sister's lawyer having that knowledge, and perhaps that informed the termination. I don't know about this. The timing is a little tough. I don't know. I'm not as in on this, like, oh, well, she was suing this other influencer and now the lawyer knew and somehow this is why they decided to terminate her. I think their other retaliation claim for me carries more weight. But again, we don't have all the facts on this. And this, of all of the causes of action, is the one that is least kind of fleshed out in the complaint. It just says she was asking for employment records from Erica Costell's company, and they have the same lawyer as sister. And that happened in May. And then in September, she's terminated. I don't know about that. I don't know about that one. This one, I don't know. If there's more information there, I reserve the right to change my mind. But on this retaliation, I don't know. I will have to pull, if you want me to pull that lawsuit, I'll pull it. See, if the lawsuit was also initiated close in time, it might change my mind. But the requests in May and then the termination in September are a little distinct in time for me. But you never know. Under this cause of action, they are alleging that there is a civil penalty attached, $10,000 for each violation of the labor code under that, possibly why it's included. 10th cause of action for wrongful termination against sister only, against public policy and the California Constitution. Again, you can't discriminate against somebody based on disability and terminate them for such. Prayer for relief. The prayer. It's just like a prayer. Yes, it was a Madonna reference. Just like a prayer. Remember when that was the most scandalous thing that happened in music and not like Satan shoes and stuff? Religious iconography and music always gets people all riled up. All right. Unpaid wages. Hey, remember all that work I did? Pay your girl. Wages and penalties for failure to provide minimum wage. Hey, all of the penalties that the state allows tacked on to all of the wages that weren't paid, I want those too. Liquidated damages for failure to provide minimum wages. in an amount equal to the wages unlawfully withheld according to proof at trial. All the wages and penalties for failure to pay overtime and double time, all the waiting time penalties according to proof at trial, meaning, hey, you should have paid it when I was terminated. That was a long time ago. You still haven't paid it. Money judgment representing compensatory damages, including lost wages, future lost earnings, and other employee benefits, all other sums of money together with interest in those amounts according to proof at trial. General damages, according to proof, money judgment for mental pain and anguish and emotional distress. Whoop, there it is. That's why you don't want to go to jury trial, because there could be other things that happened that can be proven to a jury that impacted her beyond this. Not the injury per se, but the loss of the job, if there was any besmirching or disparaging behind the scenes with regard to her having difficulty finding other work. These are suppositions. I'm not saying these happen, but those are sorts of things that you could see for pain and emotional distress, because now you've been terminated for this perceived disability and such. Other damages, according to proof, all the other shit we can get. Punitive damages. Hey, you shouldn't have done that. You're bad. Punishment money. Civil penalties, costs for the lawsuit, costs for the attorneys, and other costs. Again, the prayer for relief is like, hey, this is all the things we want. This is everything that we want, because you need to put it in there so that the other side's on notice. You can't just ask for it later. It has to be in there. And that, friends, that is the complaint against James Charles and Sister LLC. Let's take a look at his response. It's going to be faster, and then we're going to get to questions. So let me pull that up, take a drink of water, and get into these answers that were just filed not all that long ago, truthfully. Let's pull. Yes, they're pulled up. Pull it up. Pull it up. There's two, but they're going to go fast. We haven't gone through a lot of answers on the channel. We've gone through Shia LaBeouf's answer. I think that maybe is the only actual answer that we've gotten to. So chat, whose answer do we want to go through first? Sister, or James Charles Dickinson's? Whose answer would you like to see up on deck first? Let me know. Let me know. Which one? Which one? Which one? Which answer? Which answer, chat? Oh, I'm seeing a lot of James. A lot of James. All right, we're going to go to James first, and then we'll go to Sister. For sure. All right. Thank you, chat. Let's do it. Let's do it. All right. The answer of James Charles Dickinson comes now. The defendant's answer. General denial. Hey, all that shit you said I did, yeah, that didn't happen. A general denial is allowed. I deny the things. I didn't do the things. There are no things that I did. Affirmative defenses. These have to be preserved. These are, hey, even if I did do the things, even if I did the things, I have a defense, and I will assert it now. First defense, failure to state a claim. You did not state a claim in any of that. Second defense, mitigation. You should have done something differently to mitigate the damages, and you did not. Estoppel, Laches, and unclean hands. We've talked about this in other defenses, but it is like, hey, you cannot bring these claims because of Estoppel, Laches, and unclean hands. We'll come back to that in a minute. Good faith. You did not bring this in good faith. So therefore, you cannot bring these causes of actions, excessive civil damages or penalties. Hey, I should not be penalized. It is unfair under the 8th Amendment. It is too much. And on the Constitution. Avoidable consequences. You, plaintiff, should have done something, and your damages, even if I did it, you don't get any money because it was avoidable. You didn't have to let the thing happen. You could have avoided it. Now, I don't know how you would have avoided the consequence of getting fired, but maybe as to some of the others, like if James said, hey, I'm going to pay you. And it was like, no, it's okay. You wait. It's like, well, you did that. Waiver. Plaintiff has waived the things. You have shooed it away. You cannot bring it. Consent. Really? I mean, I get that you have to protect your affirmative defenses. I would love to know how consent is theorized here. I would love to know the thought of like, yes, consent is going to come up. But again, you have to allege each of these things. No malice, fraud, or oppression to justify the imposition of punitive damages. This is going just to the damages bit so that they reserve the right to argue this if it goes to a jury. It's like, but we didn't mean to be mean. Managerial privilege. While Dickinson denies that he was engaged in or responsible for any of the alleged conduct, he otherwise alleges, based on information and belief, that the actions alleged by plaintiff, if they are occurred, were protected by the doctrine of managerial privilege. Okay, we'll see. Statutes of limitations. We're saying that under some of these labor code sections, you cannot bring this because there is a statute of limitations issue. However, if that was so on the pleading, I think they would have moved to dismiss the pleading, but there might be some technical things within there where there are statutes, but you would think that you would just move to dismiss the pleading and not be litigating it, but okay. Again, going to damages, it should be offset and reduce the amount of monies owed to sister. So Dickinson denies any liability or that he owes any money, but should it be determined, then any recovery by plaintiff must be offset or reduced on account of monies owed to sister. I'd love to know what money they think this employee owes the company. That would be fascinating. This would be like in a situation where if you had a work computer that you didn't turn in at the end of your termination, you owe that back to the company. There could be other situations where that comes up, but I'd be interested to see what their offset is. Like, I want to know. I'm very nosy. Another allegation of good faith. We did good faith, but this goes to Dickinson believes that any violation of the obligation to pay minimum wages was an act or omission in good faith and had reasonable grounds for believing the act or omission was not a violation of legal requirements and that liquidated damages or restitution may not be awarded. So these are all trying to attack the damages sought. And again, you have to preserve them now. Good faith dispute. Dickinson denies that at all times relevant, a good faith dispute existed as to whether such amounts were owed, and no alleged failure to pay wages was willful within the meaning of the California Labor Code. De minimis violation, it means it's itty, it's whittle. Look, it's not a big deal. It's just this little thing. Speculative damages. Hey, damages are barred because they're so uncertain. It'll be interesting to see what the timekeeping looks like and what the employment records look like. Can you prove the hours worked? How can that be done? But again, that's generally not going to be on plaintiff. A lot of that will fall on defendant as the employer, but we will see. Unjust enrichment. Hey, plaintiff, you're barred because you're trying to get more than you're entitled to. You're trying to enrich yourself in a way that is not fair. So you can't do that. 18th affirmative defense, legitimate business reasons. Yeah, it was not retaliation. We terminated you for a legit purpose, not because of the shit that you said. Multiple recovery, that certain things will be barred because you seek multiple recoveries for the same harm. And again, you're not going to get damages for the same cause of action unless they are specifically different damages. Due process. I mean, it's going to be alleged, but okay. No individual liability. James Charles isn't responsibility because the Labor Code section 98.6 doesn't impose individual liability. However, I think that as to the Labor Code 98.6, because we just read this shit, I think they alleged it to the company only. Let's take a look. Because now my brain's like, but I think they alleged that just to the company. Because then you wouldn't need to say it because it's alleged not. Oh, nope, there it is. Labor Code 98.6 as to all defendants with regards to the retaliation. So they are saying you can't do that. 98.6 only applies to the company. It does not apply to an individual. No employment really? That we're picking this one because you attached the employment agreement in another declaration and are trying to force arbitration, the arbitration provision, which is included within the employment agreement. But okay, go off. They deny that you were not employed. I mean, I guess as to James Charles, it's fair. They're saying, look, you're employed by the company. You're not employed by James Charles as an individual. I get it. Binding arbitration. You have to go to arbitration. We're still fighting over arbitration. You have to go to arbitration. No personal liability, reservation of rights. Hey, we're reserving the other stuff. And we pray for a judgment against plaintiffs. So this is where the defense says, we're answering, we didn't do that shit. And if we did that shit, we have defenses. And the complaint should be dismissed with prejudice, meaning you can't bring it again. As to James Charles, and you take nothing. Charles should be awarded the cost of the suit, awarded attorney's fees. A judgment should be entered in favor of Dickinson against plaintiff, and Dickinson receive other such relief as deemed appropriate by the court. And that is the answer from James Charles. We're going to see much of the same from the company Sister LLC. General denial, hey, we didn't do that shit, and affirmative defenses. Failure to state a claim. Hey, you didn't say anything that makes this a cause of action. FEHA is inapplicable. Hey, we're not subject to that law. We don't have to do that. Legitimate business reasons. We had a reason to fire you. It wasn't retaliation. Reasonable accommodation. It's barred because you were accommodated. Workers' comp preemption. Hey, you could have gone to workers' comp. My kids are being very loud. You could have gone to workers' comp. There's a remedy for you at law. You can't come here for emotional distress related to physical injuries because they're barred by workers' comp. However, that would only, I think, bar the emotional distress, the damages. Yeah, the damages for emotional distress. Failure, but it's not really emotional distress from the physical injury. That's interesting to me. Failure to exhaust administrative remedies. Hey, there was other stuff you should have done and you didn't, so you can't just go ahead and sue us. Mitigation. Again, you owe us. You could have mitigated your damages. You could have done other things to reduce the amount of damage that you suffered. You didn't. That's not on us. Too bad, so sad. Estoppel, Laches, and unclean hands are such old remedies. It feels like law school. We'll get into Estoppel, Laches, and unclean hands in a second. Good faith. We did all the things we were supposed to do in good faith after acquired evidence. Sister denies the things, but the claims set forth in the complaint will be barred or limited to the extent that after acquired evidence establishes that plaintiff was treated appropriately and her employment was properly terminated. Due process, avoidable consequences, waiver. We talked about these with regard to James Charles. Consent, again, you consented to all the things. No malice with regard to the punitive damages, those punishment damages. It's like, you don't punish us. We had a legitimate reason and we didn't mean it in a mean way. That's a way oversimplified, definition, but you get what I mean. Statute of limitations, undue hardship. They deny that FEHA applies, and thereon alleges that plaintiff's complaint is barred to the extent that the accommodations proposed by plaintiff would have created an undue hardship on sister. So when we talked about the reasonable accommodations for disability, I said there are some circumstances where you don't have to accommodate, and that gets into the undue hardship accommodations. Again, we'll see how that goes, and we'll talk about it more in there because that is deeply specific within employment law. But it could be, hey, we can't make accommodations for some of these things. Again, it's going to depend on what the accommodations were. If it's like, hey, I need 2 weeks off and I need to work not more than like 6 hours a day, that's probably not going to fly. But we'll see. We don't know yet. Failure to exercise reasonable care, that plaintiff contributed. This is like contributory negligence. Plaintiff contributed to the things. Offset, you still owe us some things. And if you do get damages, it's offset by what you owe us, and that will be proven. Good faith. We did it. We didn't mean to. We did it in good faith. We thought we were fine. We didn't think it was illegal. Good faith dispute is the same. De minimis violation is going to be the same. Speculative damages, again, hey, you can't prove what you were owed. Unjust enrichment, you can't get essentially double damages. No disability. FEHA doesn't apply, but if it did, you did not have a disability. Plaintiff did not have a known disability for which sister was required to reasonably accommodate. Yeah, it doesn't count. Essential duties, excessive civil damages and penalties under the 8th Amendment, multiple gravery we talked about, binding arbitration we talked about, reservation of rights is going to be essentially the same. Plaintiff's complaint be dismissed with prejudice. Sister awarded costs, attorney's fees, judgment entered in favor of sister. Look, man, I have had typos in my thumbnails. I'm not going to shade anybody for a typo. It's just funny to me. No shade on a typo because I do it all the time, but sister. I think it's funny. Sister receive other such relief as may be deemed proper. Oh, those are the answers. That is the lawsuit. We got through that fairly quickly. We will get into the nitty-gritty details of that. Do we need to get into Estoppel and Laches? Tell me in the chat if you actually care. Tell me in the chat if you want to know a little bit about Estoppel and Laches, because yay. Again, with regard to the answer of a complaint, it's no shade. It's literally their job to present every possible defense to preserve their rights. That is what they have to do. They have to do that in an answer. So it's not like, why are you being so mean? Why are you saying this and this and this? It's really just saying, hey, I have to preserve all the rights. So when it comes to that, there is no shade there. It is just what it is. So Estoppel essentially is like, hey, you can't, because I see you in the chat saying, yes, I'm curious. So Estoppel, Laches, unclean hands. I saw the comment, is unclean hands COVID related? Yes. No, unclean hands is generally that you've done something to contribute. There's some fraud kind of on your behalf. Estoppel, again, being like, hey, there's some inconsistency here. You're stopped from bringing this claim because of your own action. And that's where Estoppel comes in. You've done something that blocks you from making this argument. Laches is similar to that. There's been action on part of plaintiff that has delayed things, and therefore you are again stopped from bringing it. So that's why all of them are in there. Estoppel being like, you've done something, so we can't bring a claim. Laches being like, yeah, but you waited forever and you can't bring a claim. And unclean hands being like, yeah, but you've done fraud things, so you can't bring a claim. So that's generally, very, very generally what I need to do. A law nerds definition. Someone remind me. I'm going to have to do a law nerds definition of Estoppel, Laches, like sit down and go through it. Estoppel, Laches, unclean hands. Unclean hands is like, hey, that shit's whack. You've done something that's a little bit dirty, and now you can't turn around and sue me because you did some dirty shit. Let's see. Laches is, you waited too long for that shit. That shit took too long, and now I can't properly defend myself because you waited. You knew in 2018 that all of this existed, but you tick-tock on the clock. That. All right, you guys, we have over 4,000 law nerds watching. Did you know that if you want to be a law nerd, all you have to do is subscribe to the channel? Look, let's see if we can turn this little number over while we're here from 96.6. So if you're not subscribed, double check, because YouTube has been helpfully cleaning up subscriptions. So you might think you're subscribed. You might not actually be subscribed. So go ahead and double check that. If you haven't liked the video, do that thing. And I'm going to do one more plug. If you are not part of the text crew, if you are in North America, go ahead and hit textemily.com from your mobile, and you can get into the text crew where I can keep you in the loop. I answer questions when I can. I will text the text crew things that I don't put on social and kind of share stuff, but it's my way to let you know when I'm going live, what platform I'm going live on, or quick thoughts on things. And that is a great way if you don't get bell notifications or just want a reminder that I can keep you in the loop, or if I'm going live like on Instagram late because Rachel Hollis has done something crazy. The text crew will keep you in the loop there. And I love it. The text crew is not, here's what the text crew is not for. It's not for you to ask me legal advice. When that happens, I will be like, I can't answer your legal questions. Buy this. My answer is get a lawyer. So that's what the text crew is not for. So like the video, subscribe, be a law nerd, and let's get into questions. If you can, put a question before your comments so I can see it, because I know you guys have been chatting in the chat, and I love that you're chatting in the chat. I'm going to go through and try to find some of the super chats if I missed any. And thank you for being interested in this, and for being such great law nerds. What do you guys think of this? Is this wild? Is this wild to you? This is kind of wild to me. This is there's more information here than just an employment suit, I think, right? I thought there was more. There. And once we get into some of these other motions, we'll get more information. So let me go and find my back super chats. I'm sorry that I can't pull them up on the screen. I have lost them for sure. And that's just what it is. So let me pull these up so I can answer them, because I've learned how to do that. P. Worsmean, I thought I got that. Hello, thank you. As a Seattle salary employee that is working 18 plus hours. Oh, did you hear it bing? It binged. It did the things. You guys did it. I need a little dance. Tech, do we need a dance when it rolls over? We might need a dance. Anyway, yay! You guys did it. Thank you. All right, let me get to this $50 super chat. Thank you so much. As a Seattle salary employee that is working 18 plus hours a day, I feel the pain. I'm a channel member and purchased a bunch of merch, but when I work, I miss the lives. I appreciate you bringing attention where there would be none. You're so welcome. Thank you. And thank you. Thank you for your support of me and the channel and for being here. 18 plus hours is a lot of work. And as a salaried employee, an exempt salaried employee, that can be a lot. I've done that. I feel you. There was no overtime at the DA's office. It's like, oh, you need to keep working to get your shit done. Okay, then. You go right ahead. Rena said the D in Emily D. Baker stands for danger. Sometimes it stands for dongle, but yes, it stands for danger. Sometimes it stands for don't try me. Vaughn Loren with a $10 super chat said, September 2018, James started a feud with beauty guru and founder of Makeup Geek Marlene Estelle after learning she was making a documentary about the beauty industry with Netflix under vulture.com. Interesting. We'll have to go look. Yes, it's lip gloss. Just Martin Rogers, $5 just for the YouTube at all costs singing to the rafters. Yes, thank you. P. Worsmean, I hope I said that right. Thank you for the $20 super chat just because I love our community. Thank you. John Brownwell, isn't the name Sister Sister LLC a ripoff of the TV show Sister Sister? Emily, I hope your colorist stylist is around the clock standby. We'll get it taken care of. Octonation with a super chat, sister sub to Emily. Thank you. Yes, I love the lip gloss. These are Gerard Cosmetics. I saw Jen Gerard in the chat. Hello, friend. I hope your move went well. And yes, I love them. Yes, I love the lightsaber lip gloss. Yes, I know we can't call them that because, Disney, but I love them. Miss Pockets the Riot said, I hope you and your family have a great week. Reminder to everyone to check in on your mental health and take care. Yes, mental health on social media has been very strange lately, particularly watching like the Gabby Hanna stuff. If you watch this community, that has been a thing. John said, it's very near purple hair time. It is, and I do have purple hair dye. Miss Opinionated said, did I miss the Britney Spears case? No, because we're talking about James Charles. I will talk about Britney. Well, if you guys ask me about Britney, I'll talk about it, but I'll talk about it more on Friday Night Live because not much happened at the last court hearing. And I am going to attend the next court hearing myself and then tell you all about it. Max Mom 2004 said VA has been so slow with vaccines. I had my first shot Sunday through my son's job at Kroger. I'm 56. He's 17. I was hospitalized for 3 weeks with COVID in November 2020. Lawnerd Love, thank you for the super chat. I hope you feel well. Thank you. Thank you. And let's just get into the questions as we can get to them. And I will do my best. Courtney Carol, is good faith a valid defense? It's an affirmative defense that can sometimes reduce damages. I thought that not knowing the law wasn't a valid defense for not abiding to the law, like with contractor law. Generally, yes, there are some instances where good faith can apply, like, hey, we adhered and fired you for this reason or that reason. So there's some areas where it can reduce damages. So that's what it is. Maria asked, question, does California labor law have a pro operario interpretation provision? I have no idea. I am not a labor law specialist. If so, can it be applied to discovery? Don't know. Not a labor law specialist. So I don't know, but thank you for asking. I wish I knew. I can find out. And if I remember, I will look it up. Question, does having a concussion count as a disability? Confused about the response saying it isn't. I have not pulled the case law on it to see whether it's going to be a protected disability. Most injuries do count as temporary disabilities, not permanent disabilities. So it's like, hey, you have a, broken leg that needs workplace accommodations. So there are definitely is room for that under the reasonable accommodations needed with regard to work because you're recovering from a injury. Different than permanent disability. So, and you would need reasonable accommodations for the time that it was practicable. And that would need to go through medical and HR and all the things. Oh, Madison, you're inspiring too many people to be lawyers. LSAT and law school admissions are rough out there. Oh, Madison, that is so sweet. I don't know if I'm doing that. It's a very interesting time to be a lawyer. I'm sure law school's a whole thing, but I think more lawyers if more lawyers are good or more lawyers not. I don't know. We'll see. Good lawyers doing good work are always needed. Question, why is Sister LLC listed as a foreign company? This is a great question. They are a Delaware corporation. So they are a foreign company in California, meaning foreign to California. They are registered in Delaware. Delaware is a tax beneficial state to be registered in. Wyoming's another one. It's not uncommon for companies to be registered, but with California, you still have to register in California and pay taxes in California if you're operating out of California. There's a whole lot that goes into that decision made between CPAs, attorneys, and the business themselves. But that's why they're listed as foreign, because they are a Delaware and not a California corporation. Miss Pockets the Riot. Hello. I am doing well. It's been a busy day. I'm starting to feel it because I have been under the weather. I was in a clubhouse room today with the wonderful crew from Insider. I was on a Zoom call earlier today. It's been a busy day. It's been good. We're getting there. Question, why did she not say how much money she was requesting, and did she need to give any evidence at this point? No evidence needs to be given at this point. I have not looked to see if there's a discovery stay because of the appeal. There may be, There may be a discovery stay because of the appeal. I have not looked, but no, she does not give any evidence to the court. It is not the time for that. It is the time for the parties to be doing discovery, but there's an appeal. So discovery may wait until the appeal is done to see if they have to go to arbitration, because why go through all the discovery if you're just going to go to arbitration? So they may have agreed to stay discovery in some of the many legal documents. I have not been through every single document in this case, so that may not happen. Why did she not say how much money? Because they are going to wait to prove it up. I imagine that she's going to say, look, I need to prove how many hours. They gave that, broad general, like, hey, this amount to be proven at trial, this amount to be proven at trial. And if they don't have all the information of the exact amount of overtime and stuff, then they don't really know exactly how much she's going to be owed under all of this. So let me continue on. I missed some super chats. Thank you all for the kind super chats. Let me see if I can catch up to them. Maria, this is also a great question. If California labor law is public policy, so there is some that's public policy and some that's actual statutory that's alleged. And no, a lot of these waivers aren't going to apply to all the things. They're going to apply specifically to the damages. Hopefully that answers. Jennifer, were you ever involved in any of the Scientology lawsuits in LA? Will you be covering the Danny Masterson? I have not decided about the Danny Masterson case. May 18th is the preliminary hearing. I have not decided yet. I was working for a judge that had dealt with one of the Scientology lawsuits and had a bunch of jury intimidation and witness intimidation stuff go on with that case. But I did not work on that case directly. The judge I worked for did. Where are the exhibits? Why wouldn't they add them in the complaint? I want to see the receipt on those texts. They don't have to if they don't want to. So that is definitely their choice because it's a complaint. There are exhibits attached to some of the other declarations, but it's not the receipts, if you will. It's the employment agreement and things like that. So we're not to the full receipts phase of this absolutely yet. Somebody asked about how is Laches different than statutes of limitations. It was most simply, if there was a statute of limitation that hadn't been met, you could say or try to argue Laches. It generally wouldn't fly. Yay, Jen Gerard Carlisle. Finally, it's been a rough few weeks. I'm sure it's been really busy. It's very, very good to see you. Elizabeth B. Sister talk about a two-way twister shaking up the family tree. I love this. Oh my goodness. My child is outside the window of my office and scared me. I'm live. Why? Because I'm talking to the law nerds about James Charles. Why are you banging on my window outside? No, I can't look. Bye. I was like, why is there something? I have a window right here to my to the front, and I was not expecting my youngest to be out there banging on my window. He scared the bejesus out of me. Oh man. So the sister lawsuit hasn't been ruled on yet. Oh, John, no. There have been lots of rulings, but no, we are paused. Will they appeal going to arbitration? They want this case to go to arbitration. It is very clear they desire arbitration. Kate Ray, thank you for the surprise birthday gift. Today is my second birthday in full-on lockdown here in Canada's capital. Love to all the law nerds. Kate, happy birthday. If you're part of the text crew, I have not sent out birthday wishes yet. So if you're part of the text crew, that will come through later today. But happy birthday. And I'm sorry that you're in second full-on lockdown in Canada. It's a lot. It's an absolute lot. So I hear you. Kibby, hello. So glad you're better to do a live tonight. Not gonna lie, went through some Emily withdrawals yesterday. I'm sorry. Your lives really do make my week. Thank you so much. I appreciate that. It's why I did this later today. This morning, I wanted to do the Clubhouse, but then I needed a minute. I went and got a hamburger and a Coke. I felt better. So that's where we're at. Let me make sure I didn't miss any more. And I did. I'm sorry. All right. Nocturnal Ethereal, thank you for inspiring me to start learning law. I live in Canada, but the way you break down law makes it so fun. I think it's fun too. Thank you. I try to make law approachable. Look, we're not doing an entire deep dive into all the aspects of the things because it's not legal advice. It is a general understanding. No, I'm just sick. I had a COVID test. My kiddo had a COVID test. No, we just have a cold. It's very weird to be sick without COVID now because it's like, no, I'm just, remember when people used to get sick and it wasn't COVID? That I have a cold. It just kind of knocked me on my butt for a few days. I have not been sick in a very long time. I think it's all the hand sanitizing and mask wearing and not being out around people and things. So it is. Christina, I'm 100% sympathetic to Kelly, but does James have a stronger defense if she caused her injury by being reckless, like hiding, like riding a bike without a helmet? Not to terminating her, because she's not alleging the injury. She's alleging that she was terminated because of her injury. So it doesn't really matter why she was injured. She could have gone skiing and injured herself, but not been able to work because of her injury. She's not alleging that this was a workplace related injury. She's alleging that her work discriminated against her or retaliated against her because she had an injury. I'm very interested to see more information. I don't know if we'll ever see more information, but the circumstances of that and how it happened, I would love to know. So I don't know if we're ever going to know, but I would love to know. Just Ashley, hello. Just hoping you'll earmark some funds towards catnip toys for the little paw nerds. I will absolutely. The paw nerds love their toys because they are kittens. So yes. Vaughn, we call all of the pets paw nerds. So I know Jen Gerard regularly shares her paw nerd on Twitter. Twitter has active paw nerd threads where everyone shares their pets watching the show, cuddled up with them while they watch and have conversations. Their cats trying to attack my earrings. So all of the paw friends are paw nerds. Question, can someone get on video and claim cease and desist like Michael Scott bankruptcy, or does it need to be filed? No, you need notice of a cease and desist. You can't just get on Twitter or get on a video and be like, I demand that you cease and desist. Not how that works. I declare bankruptcy. No, that's not how it works. That's not how it works. So New Law Nerd, welcome, Mandy. Love how much you clarify everything. I try. Miss Opinionated, hello. I watch your TED Talk. Was great. May I ask what your shoulder injury was? You're a badass insurance agent, works 60 to 70 hours, commission only. Hello. I have rotator cuff and ligament injuries in my shoulder. If you've watched my TED Talk, I talk about my shoulder injury. It still bothers me, and it's still like that injury has impacted me in ways that I'm still dealing with. And that was in college. Like, injuries can mess you up. I think it's why I had such a strong response, like personally, to Jeff Wittick's injury. Like, yes. And if you guys aren't following Jeff Wittick's videos regarding his injury that happened while he was doing stunts with David Dobrik and the Vlog Squad, again, I think that probably is a workplace related injury, but we haven't seen any litigation over it. And he might not choose to do that, or it might all settle behind the scenes. We don't know. It just, those, the level of like, do it for the vlog, and the level of stupidity that could have resulted in somebody losing their life, but somebody who will be potentially permanently altered because of that injury. I know what having your life changed by injury is like, and mine weren't traumatic brain injuries. And I know people who have suffered and still survive with traumatic brain injuries, and it is a life altering thing. So it really hits different when you've had, when something is more relatable to you because of your own experience. I'm going to try to get to a few more questions. Leonards, I love seeing you wish everybody happy birthday. Dan, hello. I don't have a Discord. Do I plan on creating one? It's been discussed. I am trying to figure out practically how to find a good solution to let the Law Nerds have a community where we can all discuss. I have not come to a decision or a solution with regard to that yet, but it is on my mind. Take care of Southern California for me. I hope it's doing well. I mean, you're going to have a very interesting governor's race in SoCal, it looks like. So there's that to look forward to when politics essentially becomes sport in the state of California. And you've got a recall with the governor and possibly a recall with the district attorney. It's going to be very interesting in California. And I will be keeping an eye on it for sure. Omega, it's Dana. Oh my God, it's Dana. I get it. OMG, it's Dana. Here, wait. Ding, ding, ding. See, it's hard to break up the letters because dyslexic. Your son made me laugh. When my brother was a child, he thought it was scared the big Jesus out of me, and my family has used this expression for 20 plus years. That is fantastic. I love it when kids hear things the way they hear things. They hear things sometimes differently. I love it with song lyrics, but I love that. We not just the little Jesus, the big Jesus. I love that. Thank you for sharing that. That's hilarious. Oh, I love it. Courtney, having seasonal allergies during COVID has been awful. Every time I sneeze, I get glared at. Right, and it's not your fault. I was out the other day and somebody actually pulled down their mask to sneeze, and I was like, look, I get it that you don't snot all inside your mask, but that's literally not the point. Question. Can you explain Clubhouse and if there is a cost to join? I'm sorry I keep referring to Clubhouse so casually. Clubhouse is a iOS only, I think, approval-based app that is a chat-based app. The Twitter Spaces is a competitor. I think Instagram and Facebook are coming out with competitors. I'm waiting for YouTube to have a competitor, but like it's a video platform, so maybe they won't. And it is essentially a chat room where you can have conversations with lots of different people. It's growing in popularity among companies. There is a wait to get in. You can apply to join. You can reserve your name. And then if somebody you know has an invitation that's in, they'll get a notification and they can let you into Clubhouse. It's fairly international from my experience with it. There are a lot of YouTube creators that are on Clubhouse. And a lot of companies using it, companies like vidIQ, companies like Insider. And so they host different chats. Mr. Beast and Daryl Eves have had rooms. Who else was in there? There's quite a lot of celebrities that'll have rooms and just be in there talking about stuff. And you're like, this is happening right now? Clubhouse is very interesting to me. I don't know how long it will last once the competitors gain traction, because if you have Twitter Spaces, you can do the same thing on Twitter, and if you have followers there, you might have more people there. So I don't know. I don't know how Clubhouse will gain traction, but we'll see. So that's what it is. Question, do you think there's some correlation with all these YouTubers having injured employees? I think the correlation is being young, not always making good decisions, and a shocking lack of awareness when it comes to HR procedures and policies. I'm sure people in Team 10 have been injured and things as well. I mean, when it comes to the prank YouTubers, it's less surprising. With this employee, she said she was injured in James Charles's presence, does not say she was injured at work on the job because of the job. So we'll see. I also wonder if there were any short-term disability benefits, but with only 5 employees, I am guessing that maybe there were not. But if there were, it would definitely factor into some of this. Oh, hello, Octo. Catnip fun. Look, these kittens are crazy, man. I'll tell you what, they are regularly up at 4 a.m. because they're kittens and it's fun. Veronica K, I decided to go back to school for paralegal studies. I hope my professor is enjoyable as you have been. Well, thank you, Veronica K. I hope so too. Don't hold your breath. Paralegal work is fantastic work, but not all of us. Not all of us. And I also don't have to teach a course day after day. I like doing the guest appearances. Though I would consider teaching a course. So yes. Let's see. Question. Is California a right to work state? California is an at-will employment state, but it is not a right to work state. And this, I have the employment contract. If you guys want me to go over that, I'll go over the employment contract. I don't know if that's interesting to you to go through employment contracts, but again, not an employment law expert. Employment law is tremendously niche, which is why we're going over the broader implications of this and not the kind of nitty-gritty of all of it. Pam, this awesome live stream makes dealing with COVID vaccine side effects so much better. I know they can be really rough. I'm grateful for you and my second vaccine dose. Pam, thank you. I'm glad for you too. I'm going to stop saying the V word because I may get, I don't know. I worry anytime you talk about it, positive or just be like, yes, there can be side effects. I always worry what happens with videos. So there we go. With regard to Jeff Wittick, I can't believe he hasn't sued yet. Jen McEwen, I'm of two minds on this. There may very well be a settlement that has happened. I mean, Jeff has said, hey, I'm not pursuing legal action. There's nothing legal. But there may have been a payment and release behind the scenes, and they might have agreed like, hey, Jeff and David, hey, you can release videos on this. I'm going to pay for these things and give you this lump sum because this happened and you're not going to sue me over it. That might have happened behind the scenes. And that, again, I'm not going to speculate or throw shade at anyone's decision to do that, because if Jeff really doesn't want to sue his friend and his medical bills are paid and he's taken care of and he can make videos on it, then he might have chosen that was the way he wanted to go. Because some people, and even people I've consulted with on things, I'm like, look, the end goal, will you sue this person over this? And if the answer is no, I do not want to pursue litigation with this person over this, then it's like, okay, let's try to find some other type of resolution. So arbitration is where you deal with a neutral third party who helps the two parties resolve, and that result is binding. So you hear of mediation and arbitration. I wonder what the Arbitration Association says their specific distinction from mediation is. I'm going to look because I haven't looked. It's been a while. And I'm like, no, I just knew. Let's see what they say. What they say they're different is, because there are two things. There are mediation and arbitration, and they come with different rules. Yeah, I mean, it's basically the same as mediation, an out-of-court resolution of a dispute between parties to a contract decided by an impartial third party, the arbitrator. So contract specific is what the Arbitration Association says the difference is. So contract dispute specific, which is fine. Question, what is the file date on that suit? Jamie, we talked about that when I did the overview at the top of the show, but because I have my notes available, it was March 2nd, 2020. Quirky Beauty, I had a serious horseback riding accident at 14 that resulted in a life-changing TBI. I feel for you. And it can be very, very hard, especially if people aren't aware of TBI or dealing with TBI. I think there's a lot more awareness now when it comes to the side effects and impacts of that, but it can absolutely be life-altering. We talked about that. Jake's Baby Cakes nailed that. We're going to go for some, I missed some other questions. we're gonna keep going. We're gonna keep going. What do you think about Caitlyn Jenner running for governor? I mean, Robbie, it is all the things we love about a California political race. A media personality, an Olympian, a trans woman who's running as a Republican. I mean, only in California will you see that all happening. I will be interested to see what the platform that Caitlyn is running on. Like, what do you want to do with California, Governor Caitlyn? Or are you bored? I don't know. Like, Caitlyn recently started a YouTube channel. I want to see what the platform is. I will believe it when I see it on a ballot. I won't be voting, but I will believe it when I see it on a ballot. Who knows? Who knows? But yes, I want to see the policy there. So for sure. All right. I'm looking for questions. There, see, talking about clubhouses. Perez Hilton seems to be on Clubhouse a bit for sure. Clubhouse needs to get on Android. Jakes, I get it. I wonder if Clubhouse is just trying to be elitist. Lots of executives and VC people too. There are lots of access to people that you don't otherwise have access to on Clubhouse. It's very interesting. Liz says James Charles is steadily making Jeffrey and Shane credible in Dramageddon 1. I mean, the more we know, the more we know. The more you know. I'm so glad somebody brought this to our attention because I really don't just go searching around somebody's name to try to find if they've been sued or not. When I was looking for David Dobrik stuff, the only thing I found were his divorce papers from when he married Jason Nash's mom. I thought that was all a joke, but the divorce papers were actually filed. I didn't even pull them up because I was like, oh, everybody knew this was a joke, but I didn't follow David Dobrik in the Vlog Squad regularly. I'm like, wait, why is David Dobrik getting divorced from Jason Nash's mom? And then when I went back and found the video, David Dobrik did it as a joke, flew Jason Nash's mom to Vegas, actually got married. I thought it was a joke. It was not, because the divorce papers were filed in Los Angeles and they had to go through a divorce proceeding in Los Angeles. It was wild. So please go over the contract. Please go over the contract. Please go over the contract. All right. We will do another video with the employment contract for shores. All right. Coming up, Daisy. I would have stayed up more in Civ Pro if my prof taught jurisdiction like you. I mean, it's totally fair. Not everybody brings the same energy to it, but also I get to choose what I want to talk about. I don't know how much professors get to choose what they want to talk about and how you make it interesting year after year. They have to follow the pop culture stuff. Let's talk about jurisdiction in the terms of beauty influencers. Most professors would be like, what? Miss Minnie T says, am I the only one who is wondering where James's humanity was in all of this? Who sees someone in the hospital and says the video needs to go up now? Again, these are the allegations. These are what she alleges. My speculation is that there is something to document to back that up. I don't know who would say that. Unless there was a speculation that her injury wasn't what they said it was. Again, speculation on my part. I don't know, but I mean, raise your hand in the chat. Put a 1 in the chat if you've ever had an employer do something and you're like, are you even a person? Because we've had those bosses, and you've also had those coworkers who every little thing is like a huge thing. So I don't know the whole work culture environment, and maybe we'll find out more as this is coming to light now about that. So I don't know, but yes, I absolutely have questions about that. But again, a complaint is allegations. And unlike other lawsuits we've seen, we're able to be like, oh, these statements are alleged. Oh, here's the video with the person saying the statements. We can all go look for ourselves. We don't know what happened in this employment relationship other than what we have in these documents. So we will see. Thank you for this, Kelly Chambers, who says at will doesn't protect against unjust termination, like using cultural fit as a reason to terminate an employee that could lead to a lawsuit. Yes, at will does not allow. There are rules, people. Society has rules, and employment has rules. There are things you can fire people for and things you cannot. Question speculation. So South Florida has something called non-binding arbitration. Why not mediate instead? Does Kylie have anything like that? Amy, I have not seen an option for non-binding arbitration because I don't know. I don't know what the point would be and what context you would want to use it in, unless it was to resolve like parts of a dispute. But I have not seen that. Again, not an employment law expert. So whether there is quirky little options for non-binding arbitration, there could be. But again, I don't know what the point would be because you would want it to be binding. Otherwise, why spend the money? Unless, again, it's to resolve particular pieces of a dispute in the context of a larger litigation, I guess. So a question, defense suggests plaintiffs could have went through workers' comp. Was worker comp covered part of I didn't go through the employee contract to see. And I think it was going, when they said this could have been workers' comp, they were going specifically to some of the claims. So it might not apply to the whole thing. So we will reserve that. But I don't know if based on 5 employees, she's obligated to go to workers' comp because this doesn't seem to be a workplace related injury. So this seems to be an injury where the employer was present and aware, but was not specifically work related. So workers' comp wouldn't make sense to me in that circumstance. So you guys definitely want to see the contract. Fantastic. Jamie Riley, you make a great point. We could definitely have more likes, you guys. Don't forget to do the thumbs up things. For sure. Kelly, I'm currently reading an HR book called Can I Bring My Pet Monkey to Work? And I feel like this would be a perfect case for the book. We would definitely need more facts, but yes, it might be. And there was a DA who had a accommodation with regard to an emotional support bird. And then we also had people trying to bring emotional support animals into court. And there were lots of rules about what you could and could not bring as emotional support, which is very interesting. So Devlin, since we made the bell ding, can we have Lawyer Cat? We can have Lawyer Cat. We definitely made the bell ding. Miss Opinionated, I don't know where your super chat went. I didn't see it. And I am sorry. Let me go into the back end and look. I try my best to get to them, but let me go real quick and look on the other side so I can see it because I don't know where it went. Living Sweetly. My kid requested a salmonella candle due to the mosquitoes annoying her. She sings at the top of her lungs Lady Gaga's Bad Romance. Got in a pair of pants instead of caught in a bad romance, reevaluating her legacy thing at Harvard. No, I think that's brilliant creative thinking. And I love all of it. And I'm here for it. Miss Opinionated, I'm sorry that I missed your super chat. I've got it on the back end. What kind of evidence would she need to prove JC was there at the time of the injury? I mean, she stated that he was aware of it. So it depends on the type of evidence that they have. That could be just a deposition like, hey, at this time, place, date, this happened, and asking James, at this time, place, date, were you there? It could also be documented on social media. It could be documented in a video, depending on what happened. I mean, I haven't gone back and dug through everything that was going on in September 2018, so it could also be documented other places because social media. But deposition and testimony, somebody saying this person was here at this time with me, and if there were witnesses, and it sounded, an ambulance showed up according to the allegations in the complaint. So according who was on scene, who made the call to the ambulance, things like that, because she was unconscious. She didn't make the call to the ambulance. Question, will you give us your thoughts on the Mika Stauffer stuff? It's almost 1 year since. I don't have thoughts on the Mika Stauffer stuff because I have not dove into it that much. So I don't know. there isn't litigation stuff with that, is there? There's YouTube-y stuff with that. So maybe hesitantly. Luis, I don't know enough about it to have thoughts. I heard that happened. I'm sure there's investigations. I'm sure that he's aware that there were investigations, but I don't know. Octo, we know that you have an emotional support octopus. But do your dogs have emotional support stuffed octopus toys as well, is my question. I'm going to do a few more, and then you guys, we are going to have to jump for sure because it is 7:50. So let me do a few more questions, and then I've got to roll. A, tired. B, it's going to be time for Wired Wednesday soon, so we are going to have to do the things. But you guys, thank you for being such an amazing chat this evening and talking about all of the things. I know it got jumped. I am sorry, Miss Opinionated. I don't know how I missed it in the chat, but hopefully we got to the question about the evidence, and I am sorry that it got jumped. I try to catch them all when I see them, but I also, due to StreamYard, only have so much bandwidth on what I get to see. So thank you, thank you, thank you. Amy, thank you as always. You guys give the mods a big thank you for being here on a night we don't normally ride. I like this time. It's a good time. It works for me. I mean, I like it. I like coming in here on Wednesday night. It's been fun. I know I try to balance between mornings and evenings to try to accommodate A, our international crew, and B, everybody's work schedules and stuff. So that's why we tend to cycle through. For sure. Thank you. I have been getting lots of rest, lots of sleep, and lots of water. I have like 3 other cups here, but for sure. You are welcome, Octo. Thank you guys for all the mod love. And we did. How many likes are we at? Let's see how many likes we're at, because the cat wants to know. The cat would like to know how many likes we are at. And then I am not a cat. Now, a number of you have suggested for merch. And I think a lot of you are watching. A lot of you might be watching Keeping Up with the Kardashians, the final season, because there is merch somewhere that says Kim is my lawyer. And I want to know if that establishes an attorney-client relationship. Like if you're Khloe Kardashian and you're wearing a Kim is my lawyer sweatshirt and you get pulled over for something, are the police not to question you because you are advertising that you are represented by counsel? Does that create a attorney-client relationship? I don't know. I have questions, but the Kim is my lawyer merch is very interesting to me. I'm wondering if we need Cat is my lawyer merch. Because I feel like Cat is my lawyer merch might be epic and kind of funny. So I kind of want to know. If we need Cat is my lawyer, kind of like Dog is my co-pilot. That's the vibe I'm going for with Cat is my lawyer. We do need a lawyer cat emoji for the members. Members, I am going to add a lawyer cat emoji. I am going to do that for sure. I think that's a great idea. I will do that. What just happened? My kid is on a roll. Announced to dad that she is quitting school and she's going to Mars with Elon Musk. She is 5. Dad is going into convulsions, loving her free spirit. Tell her that, no, she's 5. Don't tell her. But Elon Musk did say, people will die. He definitely had lots of thoughts about people going to Mars. He's like, it will be a grand adventure. Many will die. Many will die. Cat is my lawyer. All right. Cat is my lawyer. You've got to be kidding me. No, I'm totally serious. I'm sister serious about Cat is my lawyer merch for sure. Thank you so much, Ashley. I appreciate that. Law Cat is my lawyer. Tech lawyer Cat is my lawyer. All right. We will discuss Cat is my lawyer. Lawyer Cat is my lawyer. Kind of like Jesus is my homeboy. That Jesus is my homeboy, Dog is my co-pilot. That's the vibe we're going for with Cat is my lawyer merch. But lawyer Cat is my lawyer might work too. is there a possibility that you designate a moderator just for super chats? Misopinionated, we do have moderators that say thank you for super chats, but I can't pull them up. I can't pull them up on screen once they've disappeared in my StreamYard. But it's always something that we can consider, that they can let me know, but I can't always get to all of them. I do my very best, which is why I have them pulled up in the back end for sure. But it also depends on how many mods we have on a given evening. Brittany update. There isn't much of a Brittany update. Let's unlawyer Cat for a second. And hold on. Let me unlawyer Cat for a second, and we'll talk about Brittany. I'm going to talk about it more on Friday. I mean, I don't know if I'm going to talk about it more on Friday. There's not much more to talk about with Brittany. Everything got put over, and she's going to address the court in June, and we don't know what she's going to say. Her attorney Sam Ingham was like, she wants to talk to the court. She's going to talk to the court in June. In June, I'm going to listen in if I can get onto the call, and we're going to talk about what Brittany has to say to the court. Brittany's attorney asked for an emergency. Brittany wants to address the court. We're going to see. Brittany wants to address the court. That's what it is. So, everything else really got put over. There weren't a lot of rulings, but I'm going to do a little update, kind of a weekend review at the beginning of Friday Night Live, and that will be swooped into that. So, yes. All right, y'all. I am tired, but we will go into Brittany a little bit more on Friday. And yeah. And then I don't know if more comes out on this. I'll be looking to see if the T channels and the commentary channels find anything in that 2018 time space that indicates what happened around there. We'll definitely be looking up I will be looking at what happens, because I'm interested about this injury, and I'm nosy. I'm curious. I'm curious about what happened, but they were very clear that they did not refer to it as a workplace injury. So we'll see. Why would Brittany want to speak to the court now? Why now? Why this sperm? It's a Legally Blonde reference. I don't know. I don't know why Brittany would want to speak to the court now. She might feel capable of speaking to the court now. She might have a change of circumstances in speaking to the court now. She might feel empowered. So we don't know. We just don't know what she wants to say. Her attorney didn't really give any indication, but that she wanted to address the court directly. And we'll see what she says. I mean, I don't think in this entire case, I don't think Brittany's ever spoken to the court directly in all of this. Never got to have a lawyer of her own that she picked, always had court-appointed counsel, is paying for all of the counsel. But it's still a voluntary conservatorship. So we'll get into it on Friday a little bit more. I will be on social the rest of this week, a little bit more than I have been, because I'm starting to feel a little bit better. So at the Emily D. Baker on Instagram and on Twitter, we are going to be, as we get into May, doing some giveaways. We've got the Pride collection coming in May. Lots of stuff happening. So you're going to want to follow on social and the text crew for that. And some bonuses coming for the members too. There's lots and lots to come as we close out April and get into May. There is still a members only Zoom call. I'm going to put that in the community tab. I had to bump the date because I was not feeling well. So that's going to be bumped. And yeah, that's what we're going to do. Scott Disick is the seller of Kim's lawyer merchandise. Oh, he's selling it through Untalented. I think that's what his clothing brand is called. That's pretty funny. Well, fantastic. All right, y'all. Thank you for a good night. Thank you for being a law nerd. I appreciate you. You know how to do the things, the liking things, the subscribing things, the social media following things. I will see you at Friday Night Live. And if you're watching the replay, thank you for being replay crew. If it's not a Friday, there's lots of other videos to watch. And I will see you Fridays at 7 and Tuesdays at 11 a.m. Central Standard Time. Bye, friend. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.